So I have the pleasure of introducing several people here. I wanted, as I understand it, this is a panel on essentially on in bello. That once the conflict has started, what is the what are you allowed to do under the current understandings of the laws of war and in cyberspace, and there are just to set the stage. There are just a couple of issues that I wanted to bring up. The key issues seem to me to be proportionality and distinction, essentially in cyberspace. How those concepts get interpreted. And in proportionality, of course, requires a balancing of the military effects, the military advantages that you get against collateral damage and so on. And if you can't calculate collateral damage, can't estimate that, that becomes really problematic. And it's, I won't say that you can't estimate collateral damage, but it's harder in cyberspace than for a variety of reasons. Also, you got to consider the possibility that it's easier to make false claims about cyber. About collateral damage. There's also the fact that you have indirect effects, that indirect effects matter a lot in cyberspace when you're conducting a cyber attack, that it's not just the computer you're interested in what's connected to the computer, and that makes the second order, the fact that it's second and third order effects that have to be taken into into account. And then there are all sorts of, in the distinction question, there are all sorts of other issues about, does attacking a computer of a non-combatant count, does that count as something bad to do? And under what circumstances is that bad to do? Let's see, what else do I have here? So other questions about separating civilian and military networks, cyber assets, and the like. Distinctions between civilian and military personnel in all of this. It was observed earlier that that the fundamental infrastructures of cyberspace is primarily civilian. So does that mean, for example, that Microsoft or Google become legitimate military targets in war, just like a munitions factory becomes a legitimate target? So all kinds of interesting questions like that. And then we had this very interesting presentation by Admiral Rogers over lunch having to do with, he was talking about culture and organizations on one very interesting question that comes up in thinking about in bello issues. Is that if you think about kinetic operations, commanders, their legal staffs and so on have a lot of experience with doing that. And so they've sort of already internalized what it means. But in cyberspace, very few people have a lot of experience in this. And so the reviews are going to be slow and time-consuming and so on. And so just because you have less experience, you're much more uncertain about how to proceed. Now, I have the... I will present people, give short introductions. I would give longer introductions, except that my laptop has gone blank. And so by the time I get down to the end, I will. Of course, right? By the time I get down to the end, I'll be able to have rebooted my computer. So in any case, and Quintin is from the International Red Cross, International Committee of the Red Cross. She has been doing. She's here to represent the ICRC views on IHL. That's her mission in the States. She has a legal background, and with that, and apologies for not giving a more complete introduction. Please continue.
Thank you. Thank you. And actually, even without the introduction, I think you already set the stage pretty well, because I actually want to talk about distinction and proportionality today. So that was a great introduction. Thank you for that. I also wanted to thank Ed Barrett for inviting me this afternoon. It's a pleasure to be here. So my task was, as Herb said, is really to present the ICRC's position on these issues. So here, the question is really, we are in a situation of armed conflict. So the questions that we're dealing with this morning about whether or not there is an armed attack. We've already solved those questions. We know we are in a situation of armed conflict, and the question here is really about knowing how the laws of war, so international humanitarian law or IHL, will apply to attacks within the context of an armed conflict. My first remark here will be to say that the ICRC's work regarding cyber warfare is still in an exploratory mode. And that was something that Mr. Clark does this morning. I think 10 years ago, the cyber warfare was almost considered as sci-fi, even for us at the ICRC. That was not something that we were really looking at from a legal perspective. That's something that we're like, yeah, that's not going to happen before like 50 years maybe, so we're not really looking at those questions. And we're now actually struggling with a lot of the questions, how do the principles of IHL apply to cyber warfare? Especially as more and more states, as it was said this morning, concretely considering cyber operations, they're equipping themselves. As Mr. Clark said this morning, 24 military have created cyber commands, so this is a concern for the ICRC. Of course, the first concern that we have is to understand what consequences, what effects cyber attacks can have on the civilian populations, and ensure that the rules regulating warfare in general are respected. But also, as a second concern, I think we really want to understand states' own understanding of the applicability of these rules and how they intend to abide by these rules, and what concrete steps states will take, what concrete measures states will take to make sure that they abide by the rules of IHL. So, and I was saying, our perspective is really maybe different from your perspective in general, because we come from the protection of the civilian population and protection of civilian objects. What matters to us at the end of the day is really that. Especially today, I think we don't know how cyber operations will play out in practice. And even if we know that cyber weapons and cyber tools in general may be very precise and then help in terms of targeting specific military objectives, at the same time, we also know that the cyber world is characterized by a high degree of interconnectivity. So the consequences, the potential consequences for real life objects are really high, and that's also why we want to look into those questions. So before going into the principles of distinction and proportionality, I think the first step is really to understand what is an attack within the framework of IHL. So not the armed attack as we discussed this morning, but within the context of an armed conflict, what types of acts constitute attacks as understood by IHL. And so if you take additional Protocol 1 to the Geneva Convention, Article 49 says that an attack is an act of violence operated in defense or in offense against an adversary. So now the question is really about understanding what is an act of violence, and so what is violent in a way. And so here, clearly something that will cause destruction, death, injury, damage, is violent, and therefore will be considered an attack under IHL. And then the three main principles of IHL, meaning distinction, proportionality, and precautionary measures, will apply to that act. But then I think the problem comes, and there's a debate today on that issue. The problem comes when we're talking about not like attacks who do not cause destruction or death, but acts that only cause disruption or neutralization of an object. So, and whether those acts amount to an attack as understood under IHL. So, for example, just stopping a power grid from working. So it's not destroying the entire thing. It's just for a certain amount of time. So just temporarily stopping that power grid, and it no longer works. So some would say that it is not an attack under IHL because it's only neutralization and it does not cause destruction. I think on that specific issue, the ICRC answer would be that this is actually incorrect. I think we should look at the object and purpose of IHL, and AHL is really about protecting the civilian population, and surely disrupting a power grid will have consequences on the civilian population. And even if it does not shut down the entire hospital, it may have consequences on the civilian population. Even if it just like stop them from having electricity in their houses, those are consequences on them, and that's what AHL wants to look at. That's what it should regulate. So then the question of knowing whether that act will be legal or illegal is a different question, but here it's really a question of whether AHL applies in the first place to that act, and our answer would be that yes, it does. And anyway, if there's no consequences for the civilian population, then I don't see why there would be a problem in applying AHL to neutralization anyway, because it probably would not be illegal under AHL. So I think AHL should apply to those acts anyway. So now, once we've decided whether or not something is an attack, then, and if we've decided that yes, this is an attack under AHL, then as I said, the three main principles should apply. So the first one is distinction, and then I think I'm more going to ask a few questions rather than give proper answers, because we still, as I said, it's still being explored by the ICRC today. So distinction is really the idea that parties to an armed conflict should distinguish at all times between civilians on one side and combatants on the other side, and between civilian objects and military objectives. So attacks can only be targeted against military objectives and combatants, of course. So now, as I said earlier, I think the problem is really that of interconnectivity. And here I'm talking more about so here the problem is more about objects rather than people. So I think the problem with distinction in the context of cyber is really more one relating to objects rather than people. Because military communication, as we know, go through civilian infrastructure and civilian networks, etc. And so that the mere fact of that civilian infrastructure being used to communicate military information, even if it's just like 1% of that civilian network or civilian stream being used for military purposes, that means that those civilian networks, streams, actually become dual-use objects. They use both for civilian and military purposes. And so, which means that they would be legitimate targets under AHL. So the problem is, as the entire cyber world is interconnected, we would come to the conclusion that most cyber objects, even if they're civilian objects to start with, would become dual-use objects, and then everything could, at the end of the day, become a legitimate target in the cyber world. So the question there is really one of the relevance and the principle of distinction today, and I'm happy to have your thoughts on that afterwards. But then the other problem that's linked to distinction, I think, is that the principle of distinction is really linked to the one of prohibition of indiscriminate attacks and using indiscriminate weapons, which means that an attack that would be unable to specifically target a military objective, so that cannot make a difference between military objectives and civilian objects, that attack would be illegal. But then again, there's a problem of the interconnectivity of the cyber world, because as we just said, even if you wanted to respect the principle of distinction, you're only targeting a military object, and the civilian networks are not even being used for military information. But if you create a worm that replicates itself multiple times to the point that you can't control the effects that it will have at the end, and you can no longer control what will be affected by that worm, and that worm may even cross borders, then how do you manage to ensure that it will not it will not affect civilian objects at the end? They will only restrain itself to military objectives. And again, I think this is the second concern, I think is even more important, is again, interconnectivity, but this time interconnectivity between cyber infrastructure and real life infrastructure. Because if you attack a cyber network, how can you ensure that this won't affect kinetic objects? Again, if you take the example of shutting down a power grid, because you want to shut down a military base, for example, but how do you make sure that this power grid is not also being used by a hospital, and that hospital, or maybe a nuclear plant? How do you make sure that those won't be affected at the same time? So that's where the problem of prohibition of indiscriminate attacks is really relevant. So those are really the first questions that we should keep in mind in that regard. And then moving to the second principle, the one on proportionality. I think, so the definition of proportionality is that attacks against military objective or against combatants, so even when they respect the principle of distinction, they may still be prohibited if they are expected to cause incidental damage or incidental civilian casualties that would be excessive in relation to the military advantage anticipated. So here, I think the main problem that we can see is really that of reverberating effects, or what we also call knock-on effects. And what I just said before on indiscriminate attacks, I think applies here as well. If you don't know what consequences your attack on the what consequences will have from your cyber attack, then how can you make sure that you comply with the principle of proportionality? Meaning that even you know that the civilian objects will be affected by your cyber attack, even if you are targeting military objective. Then the question is, can you still carry your attack even if you know that it's going to affect civilian objects? So is that disproportionate just because it will affect those civilian networks? I think the question here is one of the level of knowledge that you should have, or the level of prediction that you can have on your attack. And that applies to military commanders, but also to designers of weapons, I think. How can you know to what degree your attack will affect the civilian population and the civilian objects? And here, I think, compared to kinetic operations, where the principle of proportionality will say if you affecting a large number of objects, if you're affecting a large number of civilian objects, then it will be disproportionate. But here, I think the number of civilian objects affected is not the most relevant part in the principle of proportionality. It's more the type of consequences. Because if you take Stuxnet, it went through thousands of computers before achieving its aim, and those were civilian computers, but the high number of civilian objects affected does not necessarily mean that it was disproportionate. It's really a question, I think, of the type of consequences that the attack will create. So if it's only going through those civilian computers without creating much harm and without causing destruction of those civilian computers, then maybe those attacks are proportionate under IHL because the consequences are not major for the civilian population and for that civilian object. So I think we should understand the principle of proportionality in a different way in the cyber realm compared to the way we understand it in the kinetic world. And so just to finish on this, I think it's important here to keep in mind that the principle of proportionality really does not only concern civilian population. It's also there to protect civilian objects. So even if it does not have any consequence on people, if objects are being affected, then we should keep in mind the principle of proportionality. And I think state practice and jurisprudence haven't really looked at that enough today. There is no case where destruction or disruption of civilian infrastructure has ever been considered disproportionate, because when it does not affect the civilian population per se, then we have a difficult time saying that it is disproportionate if it's only causing harm to objects. And I think that is something that we should actually pay more attention to, because AHL is there also to protect those objects, not just civilian population. I don't know how much time is left. I think I'm going to stop here for now and let Eric maybe speak more on the principle of precautions, which is the third aspect that AHL covers. Thank you.
So my computer has revived itself. Eric is a faculty member at the law school at BYU, Brigham Young University, previously JAG in the Army, former lieutenant colonel, has experience in cavalry and in the JAG. How's that?
That's great. Okay. So, thank you all. Thanks to the same people everybody else has said thanks to. This has been great, and thank you to you all for your presentations and questions. This has been extremely beneficial for me. I really enjoyed being here. When I told people I was coming to a conference on law and ethics, you know, I got that quizzical look like, really? Lawyers? Ethics? Are you serious? But this has really been interesting to me. I mean, I personally believe that law and ethics do belong in the same table, so it's been great to be here. Yeah, I hope so too. As Herb mentioned, we are going to focus mostly on in bello, and what I want to do, I think, is raise three issues that I think, from my perspective, ethical issues are really raised, where I think I can give you a good legal answer, but I think there are some ethical considerations that may cause us, as a matter of policy or as a matter of other considerations, to not necessarily think the legal answer is the end of the discussion. So let me start, I guess, where Anne left off. She talked about a little bit about distinction and proportionality. These things are, we commonly term them as precautions in the attack. So these are precautions you have to take when you're considering conducting an attack. And humanity, I mean, these are the things you have to think about as you consider conducting an attack. What I want to do is I want to take the flip side of that, and I want to think about what are the precautions we have an obligation to take against attacks, knowing that someone is going to attack us. And let me just read you the law on this issue. The parties to the conflict shall, to the maximum extent feasible, and I'll come back to that language because that's really good language, right? To the maximum extent feasible, shall endeavor to remove the civilian population, individual civilians, and civilian objects under their control from the vicinity of military objectives, and avoid locating military objectives within or near densely populated areas. Now, that's a pretty clear standard, especially when you're thinking about kinetics, right? When we built the Pentagon, all of that stuff wasn't built up around the Pentagon at the time. When we built, we purposely put Army installations out in the middle of nowhere, like Fort Hood, you know, Texas, because that removes them from the civilian population. It's our attempt to say, we know that the Pentagon is a military objective, we know that Fort Hood is a military objective, therefore we are going to put these things, we're going to try and separate them or segregate them from the civilian population. Now, Anne's already mentioned that we can't do that with cyber stuff, right? You get statistical quotes of anywhere, at least I found them, anywhere from 90 to 98% of military communications go over civilian infrastructure. How could you possibly segregate all military communications from civilian communications? How could you possibly do that? Well, if we don't do that, we are turning those civilian infrastructure, those civilian networks, into targetable items, right? And Herb kind of raised this issue. If we get all of our technical support from Microsoft, does that mean that we have turned, by our own actions, we have turned Microsoft into a legitimate military objective? And of course, you can wind that farther down the hole and think of all of the things that we, through our actions, may be doing. We may be turning things into military objectives. We may be creating military objectives of otherwise civilian objects that would not be targetable by an enemy. So I think, so the first point of that is we have an obligation to segregate ourselves, and then I think we need to think about, are we doing that? Now again, we've got that nice legal language up at the front that says to the maximum extent feasible, and we can maybe fall back on that and say, look, we're doing all we can, 98%. Come on, that's pretty good. At least not 100%. Give us a break, right? Maybe we could try that, but I don't know. So the first obligation is to segregate. Then the last paragraph of this provision of the law says, if you can't do that, then you have to take other necessary precautions to protect the civilian population, individual civilians and civilian objects under their control, meaning other parties' control, against the dangers resulting from military operations. So what that means to us is, as a matter of law, we have two options. The first is to segregate our cyber activities, from civilian objects. So we can either take all of our stuff off the internet, we can build our own internet structure, we can do whatever we have to do, but our first obligation is to segregate. And if we say we can't segregate, then our obligation becomes to protect. So I can say to you, if you're my commander, I can say, boss, if you can't segregate, well then you better maybe start protecting Microsoft. You better start protecting all of those civilian servers. And how you do that then may become a technical issue, but the law would tell you you've got to either segregate or protect. Now, think about that not from a legal perspective for a second, because from a legal perspective it's a little bit difficult to even to kind of get yourself around that. But now think of it from an ethical perspective. Even if can we do that? Do we have an ethical obligation? If we accept that we're going to hop off this legal obligation by saying to the maximum extent feasible, what are the ethical implications of how we're conducting our current network operations? What are the ethical implications of how we are using our own military structure and creating these, or turning these civilian objects into military objectives? I think that's an issue that we ought to think about, and we ought to ponder if that's what we want to be doing. Again, the legal issue, maybe I can get you out of it via that fudge word, but how about the ethical issues? Let me go on to a second issue. So there's that idea, the precautions against attack. That's one. The second one I want to talk about is the use of civilians. Now, I know that the normal way we talk about this, at least in the legal field, is are we using civilians to do things that make them targets? Are we turning them into direct participants in hostilities? I don't want to touch on that issue because I think that's an issue that's been talked about a lot. I want to kind of put a different spin on this. You remember from the account of the attack on Georgia, Russia's attack on Georgia, in conjunction with Russia's kinetic attack on Georgia, there were some Russian hacktivists, as best we can tell, who conducted these DDoS attacks on Georgian government sites. And the real question always seems to hinge on, to what extent were these Russian civilian hacktivists tied to the Russian government, right? Were they acting as agents of the Russian government, et cetera? Well, that's kind of the question I want to raise to us today. There is a legal test. There are two legal tests. You can pick either one you like, and neither of them will really work in this situation. There are two legal tests for whether you can attribute the work of civilian groups, to the state. One is called the overall control test, and one is called the effective control test. One comes from the International Court of Justice, one comes from the International Criminal Tribunal for Yugoslavia. And they're trying to say things that were going on in either Nicaragua or things that were going on in Bosnia were attributable to the state, to the states. They were done by civilians or by paramilitaries, but they were attributable to the state. So here is the question. Are those tests sufficient for cyber operations? Can we accept those tests both legally and ethically as sufficient to monitor, gauge, control, limit states' use of individuals, hacktivists we'll call them, to bring about what states want to do? I cannot imagine, maybe you can come up with an alternate theory, but I cannot imagine in my mind that all of those Russian hacktivists just suddenly thought, well, hey, on that day, let's just attack these government computers for no good reason, right? I mean, there had to have been, there must have been some kind of coordination. But even if you think of that coordination in its strongest sense, it would not reach either the level of effective control or overall control, which are the current legal tests to attribute that conduct to the state. So I would argue that as we contemplate that, we all know this is going on. We all know the Chinese, it's not just the PLA, right? I mean, we all know this stuff is going on. Who knows, the Americans may be doing it too, using civilians. So we know this is going on. We need to figure out, I think, a better way to understand how you attribute the actions of civilian groups to the state, such that we can say that state is responsible for what those hacktivists did. The current law does not give us a standard that is workable. And I think there's an ethical question about how we do that as well. But you all are probably more qualified to deal with that than I am. Then the third thing I want to talk about is distinction. Let me again read you the law on distinction. And again, I'm taking a bit of a different approach to this than Anne was. I'm trying to take the other side of the coin, which is there's a law, well, I'll read it to you. It requires us to distinguish our own activities. We as a military have I shouldn't say it anymore, I'm retired. You as a military, and when I was in the military, have an obligation to distinguish ourselves in the attack so that the people we are attacking know it's us, it's the military. This is a government attack. I'll read you the law. In order to promote the protection of the civilian population from the effects of hostilities, combatants are obliged to distinguish themselves from the civilian population while they are engaged in an attack or in military operations preparatory to the attack. Now, we heard Professor Rowe talk about that and say, well, we could put some kind of code in there that could be deciphered later. Well, that's not what the law says. The law says, I'll read it again, while they are engaged in the attack or in a military operation preparatory to the attack. In other words, our legal obligation is not to be able to tell them afterwards, hey, that was us who attacked you. Our legal obligation is during the course of the attack, and in fact, in the preparations of the attack, we have a legal obligation to let our adversary know we are the ones who are bringing about that attack. Now, does that mean, Herb and I had this discussion earlier today, does that mean that we have to attack from a .mil address? And if so, that's pretty easy to filter, right? I mean, how do you effectively do this? That's it, we're done. So how do we effectively do this? Is there something we have, how do we effectively signal to our enemy about the attack? Now, I have a short little clip I want to show you, a video clip, that hopefully that sound wasn't my video clip erupting. No? Okay, so this, for all of you Navy folks, this should make you very happy. So I take it there's no sound. I didn't think there would be sound. Actually, I gave this to them at the very end, so I'm very grateful that they could even put it up. So this is from Hornblower. How many of you love Hornblower? Yeah, I love Hornblower. I'm not even a Navy guy and I love Hornblower. This is from Hornblower, and you see there are two ships, right? The front one is flying a Union Jack. There's Hornblower, my man. He says, there's something up with this. The Hotspur is not responding in the way it should be responding. Something's going up. Send a round by their side, he says. And so his expert marksman, who is told not to hit the ship, then fires, and you'll see the results of that. Yeah, bad shot. Okay, but anyway, so now what you see is the issue, right? It's actually, the Hotspur has been taken over by the French. You can actually stop the clip now, thank you. The Hotspur, I know. It's a 10-minute clip. Wouldn't you rather see that than listen to me? But the point is that once the Hotspur was about to engage, it could cloak itself as a British ship until the point where it was about ready to go into the attack. It recognized that principle of the law of war. Now, there's slight deviations on that when you're talking about land warfare, and I think that's fairly insignificant for what we're talking about, because the issue is still at some point you have to show yourself as who you are. So when the French, at the point where they thought they might respond with fire, they had to take down the Union Jack and put up the French colors so they would not be violating the law. Now, how does that apply to cyber? Are we just going to say, it's too hard, we can't do that? And maybe we will. And maybe we're just going to say, or maybe we're just going to say, well, that's really a political decision. That's a political issue, not a legal issue. But the law is pretty clear. The law is pretty clear. And the question is, how can we feasibly do that? How can we feasibly mark ourselves in the attack, or in the preparation to attack, such that we are abiding by the long-standing law of armed conflict. So I think those are my 3 issues. Oh, let me just make one more point about the marking yourself. Even, it's even harder. Again, I'm no computer technician, but now think not just of the actual attack, but think of latent defects. You want to sell somebody something, let's say you're the French and you want to sell an anti-aircraft missile, and you have put in a code into that anti-aircraft missile that will immediately dud if it's ever targeted on a French aircraft. How do you mark that? Do you have an obligation to mark that, or do you have an obligation to have something flash up as the whoever it is, when the Germans invade France again, they're about to shoot down a French aircraft and something bleeps up on the guy's screen and says, oh, you can't fire me, you can't fire me, this is brought to you by the French government. You know, how do you do that? So latent defects, I think, is an issue. And the second one is time bombs or even portal accesses. How do you mark yourself? Do you have to mark yourself as getting a portal access? Do we define that as in the attack or in the military preparation? Remember, it's not just in the attack. It's in the military operations and preparation for the attack. Getting access to a system, I would say, seems to me to be in the military. It's a military operation and preparation to an attack, right? I guess unless you can say, well, no, I am never going to attack through that portal. As a matter of, I'm just never going to do it. I'm just there to observe. Then maybe you're okay. But if you don't say that, if you ever think you might use that as an attack, then getting that portal access is in the preparation for the attack, and you have an obligation under law to identify what you're doing and who you are. So I think these are tough issues, and now I'll pass it on.
Thank you. Thanks. And the last person is Brad Strawser, who is a philosopher by training and has been resident fellow here at the Stockdale Center for a couple of years now.
This year.
Right? This year, okay. Take it away.
Thanks, Herb. Yeah, it's been great. I've been able to be a research fellow here at the center this year. It's been an amazing opportunity. So I'd like to thank the center and Colonel Athens and Colonel Barrett for having me talk today and for being out here this whole year. And actually, I'd like to thank the class of 62 who are with us today. Some of the representatives from the class of 62, they actually sponsor the research fellowship I was on this year, which was great. So thank you, gentlemen. But what I'm going to talk about today should be perfectly complementary. Unlike the last panel, I think the 3 of us actually might be in an accord, but maybe you might disagree with us. You might disagree with me. But I'm not interested in the law at all. I'm a philosopher. I'm an ethicist. Not that I don't care about lawyers. You know, some of my best friends are lawyers, right? But I'm not interested in the legal questions behind these things. But I do think what we need to do is figure out the ethical, the moral truth behind them that we want to try to strive for, abide by in our just war theory, and then try to get our law to fit it as best as possible. And as both of the previous panelists have shown, it might be that our law needs to adjust to fit the ethical realities of some of the natures of cyber war. So in particular, in the Imbello stuff, so recall what we're all talking about up here is war has begun, right? So we're in war and we're using cyber weapons in war, and what kind of questions do those arise for us? What do those bring up for us? So what I'd like to explore is an important aspect of our ethical deliberations on even the possibility of just war fighting with cyber weapons that I think actually has a tendency to get overlooked or at least underappreciated. And namely, I want to discuss the difficulties surrounding adherence to what's known as the jus in bello principle of discrimination, distinction, or its corollary of non-combatant immunity for cyber war. So that issue itself is nothing new in these discussions. In fact, many writers, even here at this conference, have discussed those. They've worried over whether the application of cyber force can be done in a way that is consistent with this principle. That is, many fear that cyber weapons may just be indiscriminate by nature or by design, and so thus they're not good candidates for weapons of just war fighting. And conversely, several have argued just the opposite, in fact, that they can be quite discriminate, and thus used in line with this critical just war theory and principle. So a lot of people have discussed these. In fact, what I'm going to say today, I'm indebted to Professor George Lucas's article. He has a great piece called Permissive Preventative Cyber War, Restricting Cyber Conflict to Justified Military Targets. He delivered that at Oxford's Ethics, Law, and Armed Conflict Center, I believe. It's an excellent paper. You can Google it. You can find it. I'm also indebted to a paper by John Arquilla called Ethics in Information Warfare. And both of those writers discuss this issue. So do many others that we're all familiar with. So it's not the issue that I want to focus on particularly, but a particular problem with it. This will be more clear as I go along. But so let me just say at the outset, the claims I'm going to make, I think, are compatible with both Professor Lucas and Professor Arquilla's claims. They think that the general spirit of their views is that discriminate cyber war is possible, that you can do cyber war in a way which adheres to the principle of non-combatant immunity. But, so I'm not going to disagree with that in principle. What I want to point is that there are certain problems, some of them are very pernicious, in any attempt to think through whether or not cyber weapons can be properly understood as discriminate. And these problems have to do with the very conception of how we determine what thresholds of harm we think are and are not compatible with adherence to that principle. These harm threshold determinations, the difficulties we have in determining these thresholds in turn create special problems for the discriminate use of cyber weapons that just don't trip up conventional weapons. So I'm going to focus on this one aspect of the discrimination problem for cyber weapons in the following way. The question I'm asking is this: just what constitutes harm? Or more precisely, what threshold or what extent of harm do we think is compatible or incompatible with the doctrine of non-combatant immunity, or at least some kind of attempt at discrimination in warfare? So I'm going to get into the weeds a little bit on just what harm is and what kind of thresholds we think are plausible. But the upshot that I'm going to pitch is this: I think the ways in which cyber weapons do harm, so that is not just the kind of harm they deliver, which is distinct from kinetic conventional weapons, we all know that, but literally the way they're delivered, present unique moral challenges, not just in our efforts or desires to be discriminate in war, but in what we think discrimination for these kind of weapons even would be. That is, questions of discrimination adherence for cyber weapons are conceptually difficult, and we have to answer these questions about what we think proper harm is before we can answer the discrimination questions. So non-combatant immunity, let me just press that again, not from the legal angle, but for the importance of it morally. On any traditional just war theory rubric, the bedrock principle of jus in bello, there's of course two, as have all been mentioned at length: distinction and proportionality. The idea of distinction has a long provenance, right? In traditional just war theory, you have this sharp divide between jus ad bellum and jus in bello, and the idea is that any soldier fighting in war, regardless of the justice of the cause for which he or she fights, is behaving justly so long as they follow these jus in bello rules, as long as they only target each other, other soldiers, other combatants, don't target non-combatants, and they do so proportionally. What that gives us, so that most people base that on what's called the moral equality of combatants thesis. The idea is that combatants on both sides of any fight, hey, they're both morally equal, they're fighting, and that gives us this important corollary bedrock principle of therefore don't hurt the non-combatants on either side. They're not involved. Recently, just war theory has been challenged a lot. There's some revisionist scholars out there today, people like Jeff McMahon, people like David Roden, who think that these aspects of traditional just war theory don't hold water, at least morally. McMahon has argued that we should forget about the moral equality of combatants thesis, at least morally, although pragmatically he thinks we should retain it for legal purposes. I happen to agree with that. I'm a revisionist in just war theory as well. But notice the revisionist just war theories, I bring this up because the revisionists, they also passionately hold to a non-combatant immunity distinction principle. It's not as if we do away with moral equality of combatants and the revisionist model, and then we don't have these discrimination problems. If anything, the burden to be discriminate in war is ratcheted up for the revisionist just war theorists. So on any model of just war theory you have, one of the most fundamental moral principles, if you want to say, you plausibly want to claim you're fighting a just war, is that you take great pains to be discriminate and that you don't intentionally target or harm non-combatants. I'm going to come to the harm problem. Classically, of course, this wasn't a problem, right, with conventional war. It's pretty clear what you were trying to do with the weapons you had. You were trying to kill people. You were trying to blow things up. You were trying to destroy things. So you could tell very clearly if we do a bombing raid and we blow up some buildings that civilians were in, and we were intentionally trying to blow up those buildings that civilians were in and intentionally trying to target the civilians, the non-combatants, with bombs, is very easy, and there's no question over whether or not discrimination was followed. With cyber weapons, the kind of force application we're delivering is so different that you might think, well, does that count as a violation of discrimination? So before I do that, let's real quick just try to get a rough definition of harm. What do we mean by harm? So if I say, hey, non-combatant immunity, we should try to not harm intentionally anyway, we should not harm civilians. I should note the intentionality piece there is so critical, of course. Classic just war theorists and revisionist just war theorists usually subscribe to some kind of doctrine of double effect, which suggests that if you're not intentionally harming a non-combatant, but it happens as a result, a secondary effect of an otherwise just action, that can be permissible. So just to clarify that, but if you're intentionally targeting non-combatants, what do we mean by intentionally target or harm? The concept of harm is actually surprisingly complex if you try to get a philosophical analysis of it. The best one that I'm aware of was by Joel Feinberg in 1984 called Harms to Others. More recently, Seth Lazar wrote an excellent paper called The Nature and Disvalue of Injury. I'm borrowing a bit from him here. He suggests just a real simple form that we understand harm as a setback to a person's interests, such that people have legitimate interests, and if the interest in some way is necessary to them, or somehow in any way a rights claim of theirs, that a setback to that interest they can justifiably claim as a harm to them. Now, whether or not it's an injury and a wrongful harm, of course, will depend on the context. But if we're presuming non-combatant immunity, then that suggests any harm to a non-combatant intentionally is anathema on traditional just war theory or in revisionist just war theory morally. So a couple examples here. Notice we'll bring out two things for this idea of a setback to a person's interest. How we grade the degree of harm is going to depend on two independent variables: the seriousness of the interest at stake to the person and the extent of the setback to that interest. Lazar gives a nice example. If person A punches person B in the face, the harm seems to be greater if B's nose is broken versus if you just split their lip. Well, probably both of those kind of harms would count as more severe harms than if person A just repeatedly took person B's parking space every day. So something about bodily physical harm we tend to think either counts more or is more egregious. And most people think this is not just because it's so clear, although it's at least that. Physical harm is very clear and obvious, right? We can clearly designate it. But also it seems like there's some kind of moral bedrock principle to it. That you can draw this out by showing, imagine non-physical harm to somebody that actually over the aggregate time impacted their interests more than some direct physical harm that actually impacted them less. We might still think the physical harm is more egregious. So getting back to our target then, imagine a kind of two attacks. So imagine we drop a physical kinetic bomb, like I said, on a group of non-combatants. We can know immediately, clearly you're intentionally targeting, if we were intentionally targeting the non-combatants, we're violating discrimination. Imagine, alternatively, we deliver some kind of cyber logic bomb, the kinds we've been talking about all day, on a group of non-combatants. So we drop a logic bomb. Somehow we deliver a cyber weapon of some kind, perhaps a logic bomb, on a group of non-combatants, which results in a widespread harm of the non-physical, non-bodily kinds, but to certain things that would certainly constitute clear interest to them. Does that even count as harm? A joke we've had all semester in our seminar is does blocking someone's access to Facebook for an hour, or slowing down their email, or somehow maybe getting in the way of their ability to search something online, does that even count as a moral harm that we should be concerned with in just war theory? Some of you probably think, no, that's ridiculous. You're talking about inconveniences. Who cares? That's not harm. That's not what discrimination's about. Discrimination's about just don't kill civilians in war. What are you talking about? And I'm not so sure, actually. I think since the kind of damage that cyber weapons do is more varied, more dispersed, precisely because it's non-lethal and non-physical, it often can just be a disruption or interference that we're talking about. Well, then determining just what constitutes sufficient harm such that we think an act of cyber warfare would be violating non-combatant immunity is going to be very difficult to figure out. We have to answer the harm question before we can even answer the discrimination question. So here's a couple examples. And then I'll get into kind of a stronger claim, a more forward claim that you can disagree with me on, so I can have people think I'm wrong, which is my goal of every talk I give. A couple examples. John Arquilla, he gives a nice, this is I'm quoting from here at length here. He's talking about this problem, and it draws out the point I'm trying to make nicely. He says, although it may bear, this is quote John Arquilla, although it may bear a strategic resemblance to air power, cyber warfare, information warfare, has a quite different set of effects and properties. While air power can generally perform much destruction on fixed points, cyber attacks, even if they were concomitant with conventional weapons, inflict far less destruction. So he says, look, they result in fewer deaths, they're non-lethal, and he's, of course, absolutely right in that way. In fact, you could draw a principle from this. You can say because cyber weapons do less lethal damage, they're actually morally preferable in all these ways, even if they are more dispersed. Anne mentioned this a little bit. You could actually draw a kind of obligation out of that. You could say, look, if you could accomplish the mission in two ways, one through lethal weapons, one through non-lethal cyber weapons, clearly the non-lethal cyber weapon is an advantage. But a problem I have with this is that it might come at the cost of discrimination. We might actually have two metrics here. We might have situations where we can use a cyber weapon, which is incredibly dispersed, and it's going to impact lots of people, but very little, right? It might slow down their email to use it, or maybe they can't get on Facebook. I'm being a little facetious, but something like that, right? Some sort of impact in their life, but in a minor way. So it's not discriminated at all, but is effective for this low level of harm. So this is the kind of this proportionality driving that, but at the cost of discrimination. Alternatively, we might have a very discriminate kind of attack that we could give, but that actually does physical, real lethal damage, so it loses on the proportionality side. I think these two things are going to be in conflict with cyber weapons. To get to the point on harm I'm trying to make, since I'm short on time, let me just cut ahead. I think the point I want to make is that intuitions over what constitutes harm in the cyber realm is going to vary widely. If we took a poll in this room and I asked you, does this count as harm? If we did this to a civilian set with cyber weapons, some people would say, yeah, we shouldn't do that. That crosses a line of non-combatant immunity and more. And other people would say, no, that's fine. That's just inconveniencing them. Clearly, there's the facetious stuff like Facebook access, although I'm not so sure about that, to be honest with you. Right? If people have a right and they're non-liable, if we have a pure blanket non-combatant immunity, well, if we're intentionally harming them in some way, even if it's set back to their Facebook account. But here's another problem we could have differing intuitions on. The delivery mechanisms for cyber weapons. It seems by their nature, at least the vast majority of cyber weapons, and this is points you both mentioned, that they have to travel through civilian sources. Dorothy Denning, she's a cybersecurity fantastic scholar. You probably know her. She was at Georgetown. Now she's at MPS. Her and I had this conversation, and she, interestingly enough, disagrees with Professor Lucas in thinking that Stuxnet was not discriminate because of its delivery systems. Now, Professor Lucas claims that Stuxnet was incredibly discriminate. He calls it, I think you called it a marksman's work in your paper, right? It was the work of a marksman because it just targeted this particular target in Iran. But to do that, it had to infect thousands and thousands of computers along the way. Now, you might say, look, if I'm just infected with some worm that kind of travels through my system but has no actual significant damage to my system at all, let's say it doesn't literally affect your system in any way, are you at all harmed? Many of us here will claim, no, I'm not harmed at all. Many of us here might not be comfortable with that, though. You might not want malicious software on your system regardless of whether or not it harms you or harms your system or somehow degrades its functionality. But another aspect of this, think about DDoS attacks. So you got Georgia and Estonia. A lot of people hold up both of these cases as differences on discrimination in cyber war. Professor Lucas does, so do some others. You could say Estonia seemed to be very non-discriminate. The cyber attacks seemed to kind of go after everybody, and all kinds of people had issues, whereas Georgia seemed more discriminate, seemed more focused on military and state objectives. That's fine, but notice how they were both done. They were both done through botnets. Well, what are botnets? Botnets are a whole bunch of people out there who have their computers being used against their will to carry out a cyber attack. So it seems even the very delivery mechanism itself, we might pull in non-combatants wrongly and use them. Now, again, I'm talking about in bello. So we're in war and we're trying to figure out how do we fight justly in war in a way that follows the discrimination principle. And what I'm suggesting to you is that if we don't know what we mean by harm, like is it harming somebody to slow down their computer for a bit if we want to send a cyber weapon through their system? Is it harming them to use them as part, an unknowing attack, an unknowing participant in an attack? Is that harm? I don't know about you. I wouldn't like that. How would you, I mean, who knows what the odds are, but I wouldn't be surprised if somebody had a computer here involved in a botnet attack this week, and you didn't know it. Your computer was involved. How, is that a harm to you in some way? Even setting aside for a minute degradation to your system's performance. So those are some different problems that I have, just being very quick. I could go on, but I think you get the idea with all these cases. If you disagree with me on this, so for example, if you disagree that Stuxnet, so one thing I discuss in this paper is that, so drawing on these lessons, one thing we could do with this harm problem is we could say, well, one way you could make a Stuxnet type weapon better, normatively better, a moral improvement, would be if you could somehow get its delivery system to be even more direct and not have to work through non-combatant channels. You might think that's impossible, that's going to really degrade the effectiveness of the weapon, so forth. But even if you disagree with me on that, and you think that Stuxnet would have, I think Stuxnet would have been morally preferable if the delivery mechanism had not been used, even if inertly, through non-combatant systems, then you're actually proving my point. Because my point is simply this: we have to resolve what we think the threshold of harm debate is for a non-combatant before we can understand whether or not cyber weapons can even be discriminate. We actually have disagreements in our intuitions over that, and I think that's what we miss. And until we settle that question, the bigger question about can or can they not be discriminate has to wait.
Okay. Thanks to all. I'm going to do something that I probably shouldn't do. I want to ask the first question as chair here, which I wanted to push Eric a little bit on this question of revealing yourself in preparation. So we had this discussion before, and really I want to get the audience to think about this. There is a precedent for attacks where you don't reveal yourself, you don't show your flag or anything. That's submarine warfare, right? The submarine doesn't surface and say, hi, I'm here, doesn't raise a flag, say this is the United States of America, or the last ship I know that was destroyed was the General Belgrano by the Brits in the Falklands War. They didn't, they shot a torpedo and the ship sank, and the Belgrano sank. and that was the end of it. I mean, it didn't rate, you know. So there is precedent for this, and of course, if the submarine says, "Hi, I'm here," it completely eliminates the effectiveness of the submarine. And so, Eric, if anybody else wants to comment.
So again, Herb and I had this discussion earlier, and I think it's a great point. I can only respond with two things. One would be that all of the countries basically who signed up to the 1925 protocol have since, as a matter of law, said we're not going to follow that anymore, right? So if everybody wants to say that about the principles that we're talking about here, that would be, well, I don't want to say that'd be great, but that would at least give them a legal out, right? So that's one option, or one issue. The second issue is, I think if you get attacked by a submarine, you can have a pretty good guess that comes from a military. Because submarines are not ubiquitous like cyber attacks, right? So this may kind of piggyback to what you're talking about. The method of attack, when you're talking about a submarine, that's going to give you a clue that it's either a narco trafficker or it's some state, right? Those are the only people we know that consistently use submarines. Whereas if you get attacked by some kind of cyber tool, it could be anybody. And so, in a sense, the fact that you're using a submarine marks you, as opposed to if you're using a cyber attack. So that would be my only response. I agree with Herb, though, that it's not clean and neat. Those are really the only two ways I can come to distinguish that.
I was just going to respond to that really quickly, just that I agree, and I think we do have a strong, legally I think Eric's made the case, there's a strong duty to either segregate or protect, and then you should signal, right, and so designate. But I think morally the case is very strong, right, because you have to at least make it possible for your adversary to behave morally in war. And if we're taking this idea of distinction and discrimination very seriously, well then we have to at least make it possible to kind of be attacked and in such a way that you can harm us without harming non-combatants and non-liable people. John Arquilla, in the piece I referenced, he talks about a possible policy proposal, and this was several years ago, but he said we can signal to the world by creating a separate kind of cyber command, cyber operations, cyber offensive team. We can kind of signal to say that's kind of our warfighters in this arena, leave our civilians alone, and I think that's absolutely right. I think that's absolutely the right way ahead. So I think regardless of comparison to these other forms of warfare, certainly when you're in open combat, does a submarine need to surface and wave a flag? No. But should we somehow signal to the world that, hey, this is the U.S. military fighting in this way if we're in an open war, so that they can know how to respond and retaliate, or they can know what the arbitration is, instead of a hacker, instead of a random, some other weapon. I think there's a strong moral demand on us. If we're going to take distinction seriously, then that generates an equally strong moral demand on ourselves to identify ourselves.
George?
I think there's an answer to both Eric and BJ on the excellent points they raise, and that is that in Eric's case, the body of law, and in BJ's, the body of moral deliberations about use of bellow do not apply to the examples you cite, because all of those activities, classically the false flag here, that was an act of war. False flag was an even better one than in Pat O'Brien's not Master and Commander, Far Side of the World. It's surprisable to say. Right. In wartime, yeah, they've got to raise their flag and identify themselves, but in espionage, they do not. And in espionage, false flag scenarios are used all the time. So common tactic the ethics of it are something that the intelligence community is examining, but it's a long-standing tradition and practice, as are PSYOPs prior to war, which is what those botnets are, Eric. And so it's not clear that either event or phenomenon that you're describing falls into the relevant body of the law or morality that you're citing.
Can I just, I think we both accept that what we were talking about was only once war has engaged. I agree with you about the cyber espionage stuff. I'm talking about once war has begun.
But in all the cases you're mentioning, war happened, or we don't even know whether to call those things war. Okay? So,
yeah, I agree. I don't think we've had a war yet where war has been, we have hot, open, here we go, real war, nobody's denying we're in bellow, and cyber weapons are being employed alongside of it. I shouldn't say that because we might have it going on right now, but by both parties in the way we're describing. So those are the only examples we have, but you might be right, those aren't in bellow cases.
I mean, I don't mean to press the point too hard. It's just that certainly in the Georgia example, the cyber attacks preceded the onset of conventional war. And in every conventional war where similar kinds of tactics have been practiced that use civilian objects and so forth, nothing illegal took place or immoral. I mean, those were considered to be preparatory tactics to war prior to the onset of war that are permissible under law and morality. And likewise in the false flag case, there your example is begging the question of whether the altercation is or rises to the level of armed conflict. You can't presuppose that and then argue that it's a violation, a false flag is a violation if you don't identify yourself. If you're not engaged in war, but in low-level intensity conflict like of the sort that really most cyber war has been, except for the 4 examples that problematic examples we looked at, you can't unproblematically make those claims. You haven't established jurisdiction. In Ann's case, Stuxnet is an interesting problem with regard to harm. And you've got the worm crawling through civilian computers. Is its residence there, as you correctly surmise? And BJ as well, is that harm? Just is it trespassing? So, what's the nature of harm there? But it does no harm. You're passing across or through a system, doing no harm to anything other than the eventual target. The 984 Siemens centrifuges running in a certain array to enrich uranium. If you're not doing that, it's not going to hurt you. But Ralph Langer, who raised those points initially, said the harm that's being done is of a different sort. If you followed this in the last few months, he was on CBS 60 Minutes, the German guy who first identified Stuxnet to the public, that the harm done is that Stuxnet becomes an open source weapon that any terrorist or teenage hacktivist can download it and replicate the code and build themselves a weapon that does the same kind of tricks with programmable logic controllers, very familiar kinds of software devices that control all kinds of things, and then they can make the inadvertent consequences. That the weapon itself didn't do any harm, but the fact that you used it and it's out there, now any kid can use it to do inadvertent harm, and that's what's wrong with it. I think that's a mistake, but I think it's a worthy problem to raise about the nature of unintended harm and consequences that are indiscriminate that weapons of the cyber sort might do.
Okay.
I think that's a very relevant question. At the same time, that would be true for any cyber attack. So whether or not it affects civilian computers or not, that question should be kept in mind. The open source question is there because I think cyber attacks are they would be the only weapons actually that leave the blueprint at the same time as you launch the attack. It would be like launching a nuclear weapon, and that was Peter Singer who was using this example a few weeks ago during a conference that we attended. And he was saying, yeah, that would be launching a nuclear attack and launching the blueprint of that attack at the same time, and that's exactly what cyber attacks do. I think but that's a question that's not necessarily linked to the fact that it was affecting civilian computers. That would be the case every time.
Really quick response on the trespassing. So you asked kind of what's the harm of trespassing, right? If the worm goes through and it hits Stuxnet, and it hits the Iranian centrifuges, but doesn't. You said it didn't harm the computers, just pass through them. I would suggest that there might be a harm of trespass, right? Just simple basis of sovereignty. If we did this if you imagine Canada goes to war with Mexico, and Canada says, hey, we're just going to drive our tanks through, the Dakotas and Colorado and New Mexico and down. We're not going to harm you. We're not going to hurt anything. But you might think that we have a legitimate interest to say, wait a minute, we don't want you to drive your tanks through us, even if it has nothing to do with us. We would say the same thing even if it was airspace and so forth. I know these analogies aren't perfect. You might say, well, hey, you can't apply that to cyber war because everything has to travel through other people in the cyber world. I say, well, that's a problem for discrimination. At a minimum, even if you think it's a very, very small harm, I'm not denying that for a second, and maybe it's worth it to inflict this harm. I'm just saying it's some kind of infringement upon someone's legitimate interest, whether or not they want a worm going through their system.
Thanks, Eric. This is what your presentation is one of the reasons I love to come to these things, because you really have stimulated a lot of interesting thought. I would just suggest that when you're talking about use in bellow, I don't think there is any obligation. If you can camouflage your siege gun so it looks like a mountain, then that's okay. But you are right. If what you're doing rises to the level of perfidious conduct, then you're into something in the use and go of. And we have to think about that in the cyber context, especially where we can have these freelancers coming into it. So more thought needs to be. You've raised the issue. I'm not quite sure I'm on the same sheet. BJ, what a fascinating pitch. However, let me say this. Let's not equate the legal status of non-combatant immunity with moral justice. The non-combatants are not targetable as a matter of law. It doesn't mean that they are morally good people. I am sure that Eva Braun suffered some harm because I'm sure she wasn't comfortable with that nasty D-Day invasion. And I'm sure that she wouldn't like the fact that the Russians were capturing Berlin in 1945. But morally speaking, we don't want it to be that way. Of course, the law of war contemplates that innocent and expects and permits the killing of innocent civilians, truly innocent civilians, and that's why we have the principle of proportionality, because they know the law and morality knows what the alternative is. Law and morality knows that the alternative is if you create the zone of protection against even discomfort or inconvenience, then the adversary is going to exploit that by positioning himself in the midst of whatever zone you choose to create. And so I think just war theory is not a ticket that nobody is going to suffer inconvenience. What it is trying to do is to recreate the status quo panic. In other words, restore peace for whatever reason. So I think you're raising important questions, but I don't think that we ought to go the next step and infer that there's some kind of moral dilemma about inconveniencing the Eva Brauns in the world, because I don't think it rises to that.
So I agree with you that even the very idea of suggesting that war can ever be morally justified means you're swallowing a pill that you know that non-liable, innocent people will die and will suffer. But the idea is that you are going to try to not intentionally have those non-liable, innocent people suffer and die. I'm not shedding any tears for Eva Braun or for any liable non-combatant. You're right. The law, for just, I think, pragmatic reasons, we should have this strict non-combatant combatant distinction legally. Morally, interestingly enough, I'm a revisionist, and I don't think there is a strict liability distinction over combatants and non-combatants. That is, I think there's a lot of non-combatants who probably are liable and probably do deserve to suffer in some sort of deserts-based sense. But whether or not we should intentionally target them for harm as an act of war, that's what I'm suggesting we do have a moral prohibition on. So I'm not talking about making people feel bad, or I know you use the word inconvenience, but intentionally targeting civilians' interests of their own and their internet access. I think that that's a real harm that we have to at least take seriously if we're going to take seriously the moral premonition on saying we're going to try to not intentionally target.
I have a quick follow-up.
Sure.
Do we do something wrong then if we kill two soldiers who are the husband and son of a single person? Do we do something wrong if we destroy a tank? Which means that has to be replaced by that country, which means to pay for that, they're not going to build an ambulance or a hospital or something like that. Sure. So you can see it's ad absurdum or whatever.
Well, reducing ad absurdum, your argument is that the harms all eventually roll downhill, and eventually everybody gets hurt, right, one way or the other. Absolutely. But I think the moral obligation we have in war is to try to make that harm as discriminate as possible intentionally. And that's all I'm talking about, to be clear. I'm talking about the intentional. If unintentionally, through cyber use or any other weapons, non-liable people are harmed, well, that's an unfortunate thing that we want to avoid. I'm talking about can we intentionally target them?
Okay, so let's move on here. Down there.
Yeah, Chaplain Weed, I'm at the CGSC. My point was, or question, relates to the whole thing of someone doing a cyber attack. My question is this: if someone attacks us from a a different place using computers, and we react to that attack. Isn't that the same thing as someone opening up on soldiers with either a sniper rifle, mortars, or indirect fire? We don't know where they are exactly. We react quickly to try to find them during time of war. So if I do a cyber attack and I'm in uniform on my country in a place of safety, that's the same thing, isn't it? I mean, I could get a rocket coming in if they can identify where I'm at, but basically I'm doing the same thing that a soldier would be doing with a sniper rifle or with a rocket. You don't want to be identified.
So this is kind of the analogy of counter-fire battery to cyber stuff, right? And I mean, there's lots of different views. I think the view that I take on it is, even in a counter-fire battery, the commander who launches that counter-fire battery has an obligation to make sure it is not going into some place it shouldn't. We used to do this at the National Training Center and the Combat Maneuver Training Center all the time. We'd pull one dude up into the middle of a village, have him launch one round, and then boogaloo out, because he would be safe in the 2 minutes it took to get counter-fire battery back, and then they would be launching counter-fire battery into the middle of the village. Well, that commander isn't relieved of his obligation to apply the principles of the law of war, distinction, proportionality, humanity, just because it's counter-fire. In other words, you can't say that even if we have some kind of active defense, we could not have it go indiscriminately, in the sense that it would not meet those requirements. Now, you can argue about whether just taking out a server would be indiscriminate, would have a problem with proportionality or not. That's a different discussion, but I think as a matter of principle, you can't just say, well, this is counter-fire battery, therefore it's okay. No LOAC issues.
Well, what about identifying yourself as the person infiltrating their computer program? To me, you're not even there. You're somewhere else. The computer attack itself, in a way, it could be the weapon. I mean, do you have to identify the rocket that's coming into the enemy if you're at war? No. I mean, they know you're at war. If you're taking fire from a sniper or a mortar, you're probably sure that's the enemy, and you need to identify where he's at, but he's not going to show himself.
So I think this, in a sense, goes to General Dunlap's point, which is it okay so long as it doesn't rise to perfidy? And my own response to that would be the problem with analogizing this to the field artillery being camouflaged as a mountain is that not a lot of people have field artillery. It's kind of the same argument as the submarine attack. So I would say the reason I think this is trickier than just perfidy is because if you don't identify yourself, but you're using a means that is clearly a state means, then it's a little easier to get to the point where you assume it's from a state. But if you're using a means like cyber warfare that is so ubiquitous, then I think you may have to accept a greater obligation to identify yourself as a military person or as a government, as opposed to just some other ubiquitous person, especially if you're attacking from a .com or a whatever, as opposed to a .mil or a .gov.
Hey, Paul.
Thanks, Herb. I want to press a little hard on BJ and Ann in the sense that BJ, I think that your intentional idea and the example, from your example of Stuxnet, I think you're really talking about reasonably foreseeable collateral effects or ancillary effects, because the example just doesn't apply. The intent was to have an effect on the Natanz facility and this other stuff that was reasonably foreseeable. You're viewing as intentionally targeting civilians. But the part I'm going to push back on both of you, and I think, Ann, you recognize this, because you gave the correct definition for proportionality of damage and civilian casualties, yet the language you transition to is effects language, which isn't about damage or civilian casualties, but might be about the kinds of effects that BJ was talking about, the inconvenience effects, the harassment, the I can't get to my website effects. And the challenge I want to pose and push on is what you've been talking about in most of what we've seen in cyber attacks. Distinction and proportionality as applied in bello do not apply at all. There's only one instance where they might. Stuxnet. Denial of service doesn't apply. not an attack. As you define it, not the kind of violent consequences that lead to destruction of property, death, injury to civilians. And so there may be a role for that when you get the next steps in. But the challenge and the question I have is I know you're about the spirit of the law and you're about the morality, but how do you deal with the letter of the law? What is your solution for addressing the fact that the letter of the law right now does not reach the activity that you wish it would reach?
So in full disclosure, Paul Walker wrote a great article on this issue that is really, really good. I would encourage you all to read.
And also in full disclosure, I kind of thought you would disagree with me. Conversations that we had, however long ago it was that you came in. And when do you respond first? Go ahead.
Yep. No, I think that's a great question, but I want to just make one point clear. When I was talking about effects on the civilian population, it was more a question of understanding what an attack is, and so to what act will IHL apply? And so only when we've answered that question, then comes the principle of proportionality. And that's in the definition of attack. Then I think effects beyond mere destruction and injury to people, that's where it matters. So I mean, from my perspective, disruption effects that go beyond destruction should also be considered as acts of violence, and therefore they should be regulated by IHL. Then that does not mean that they are necessarily disproportionate. Then that's a different question. When you know that it is an attack, then you apply the principle of proportionality. And then and indeed, as you said, proportionality is only about destruction and death, injury. And then if it's only inconvenience, I would say that it's not disproportionate, but that does not mean that IHL does not apply to that act in the first place. So that was just like two different points. That it's not because, so inconvenience, I agree, would not make the attack illegal, but it is still it should still be regulated by IHL, which means that everything that Eric talked about is also relevant. The way you will be launching that act, etc., would matter.
Okay. And quick. Go ahead.
No, just 30 seconds here. We're running out of time here. I want to get to more people. There's a long queue. Okay. Down here.
Oh, thanks.
Yeah.
I'm really interested in this question of whether Microsoft and Google, if they provide direct support to Cyber Command. I've worked at both Cyber Command and the UN Department of Peacekeeping Ops. And one of the questions that I've thought of when both through the lens of both of these organizations is a question that isn't just for cyber, but is for the kinetic world too, that Ann and BJ kind of touched on, and that is the principle of distinction whether a country has coerced military service or they voluntary military service just like we do. And I ask you to look at the cases of if we do conduct a hypothetical cyber attack on North Korea that turned off power during a freezing cold winter in order to eliminate an entire division versus a cyber attack on, let's say, the special, if there was a hypothetical special portion of Microsoft that was only designed to assist Cyber Command in infiltrating North Korean, area in North Korea. And only saying that because, I question it sometimes if being in a all-volunteer service, if there were areas where we're conducting cyber attacks that have drastic effect on combatants that in no way volunteered. And of course, we're seeing this in Syria, and we saw this in Libya as well. And I appreciate your term of revisionism of theories like of Waltzer's and others. But I was wondering, since that question overlaps both Ann on the legal side and BJ on the moral side, what say you?
I agree that the basis for someone's liability as a combatant for why they are a combatant should matter for us morally. Now, traditionally it shouldn't. On traditional just war theory, hey, you got this nice division, and sorry, sucks you got coerced into being a soldier, but you're a liable target. I'm not just saying that we can just say, oh, well, we can't kill anybody, we have to be pacifists, but I'm saying that it should enter into our moral consideration. I completely agree. And in the cyber world, it absolutely should agree. If a state coerces a civilian corporation to be involved in their cyber operations, then that should radically impact our view of how we treat that cyber operation by that civilian company.
Or provides a financial benefit.
Or,
it meets the business model.
That's more complicated, right? Yeah.
Okay, so white shirt over here first, and then, right, and then, yeah.
Hey, so I served with Admiral Rogers on the Joint Staff in the lead up to the invasion of Iraq. And it was really interesting to watch this. So we're planning to rain death from above on Iraq. In the meantime, then Captain Rogers is planning a computer network operation. The approval for the raining death from above went pretty quick. The computer network operations, that took forever. And no kidding, finally some crap, just drop the bottom line. That would be much easier. So is there a concern that if you problematize harm sort of to the extent that you're suggesting, BJ, and I think that's very interesting and it's worth problematizing, but if you do we at just some point say, this is too hard? We understand distinction proportionality when it comes to dropping bombs, let's drop bombs.
Yep.
And we eliminate this potentially.
And you're saying that's a moral problem.
It's a moral problem.
I just wholeheartily agree with you. And in fact, that's what I'm trying to press, that this is this real problem here, is that we might trade ability to be discriminate at the cost of proportionality. Maybe there's a cyber weapon which is going to hurt thousands and thousands of people, say, but in a really minor way, versus a bomb that's going to kill some civilians directly, but just a few. Which one wins, discrimination or proportionality? My gut's with you. My gut says, well, let's kill fewer people, right? Let's start there. But I'm just showing that this is a problem and that this metric is going to be an issue for any cyber attack. I'm with you.
Okay, so you had one over here, and then, yeah. No, you yeah.
Okay. Well, just on this point then, I wanted to ask some of the techie, the empirical question then. How aimable are these weapons? And assuming they're aimable, how predictable are the consequences? That's really important.
As the techie here at the table anyway. I mean, in principle, you could imagine being able to attack a processor with a given serial number or a given MAC address. In principle, now that's a really hard intelligence question, but in principle, you can get that. So it depends on how good your intelligence is. Okay, so over.
On the Microsoft issue, there might be some legal precedent. After World War II, in the Nuremberg war trials, 2 chemists who had worked for I.G. Farben were prosecuted, who invented sarin. Okay, so a bad code writer, using that analogy, possibly as a non-combatant, could be brought in. I mean, there is some legal precedent.
Okay, so then over there, sir.
Right. Just 2 comments now, not questions, but as far as the last 2 questions, or last 5 minutes of discussion, for the commanders, it boils down to know your weapons. The same questions that were talked, or the same issues that we're talking about right now, exact same stuff as we're talking about if we're dropping conventional bombs or using strategic weapons. The books are there, for depending on what type of weapon you're using, to say, hey, this is the size, these are going to be the effects, do I want to use them? And then once you weigh the risk, you just got to say, yes, I will, no, I won't. And if it's going to affect, say, civilian populations, especially for cyber targets, because a lot of this stuff is dual use. Electrical grid is electrical grid. Some of it is used for civilian populace, others are used by military. You're going to have to weigh whether or not is it worth taking this out right now to achieve military objectives, and is that going to have some long-term effect on the civilian populace. All that's going to come out in the risk assessment that we do before we start pressing buttons or pulling triggers.
Okay, well, we still have 5 minutes, but I just want to, for everybody who understands, during the conflicts we're in right now in Iraq, the rules of engagement gave the commander, and it was actually delegated on down to the 3-star MEF commander, the rules for engagement, for engaging a direct target, what we're talking about right here. You had to do 4 things. You had to have deconfliction of friendly forces. That makes sense. You don't want to hurt any of your own forces. The second one was that you had to have worked the collateral damage model. Now, so in the kinetic world, the Air Force and other commands have a great model where if you want to hit that building right there and you just want to damage this building, you have to have imagery. In other words, you can see the whole town. They lay down the imagery so all the buildings are visible. The model then you can play what if. What if I drop a 500-pound bomb? I got it. They put it in the model, 500 pounds, they call it a bug splat. This heading coming in, dropping that bomb, hitting at that window, so it's 3-dimensional, and delaying the fuse because you want to minimize the collateral damage. The frag pattern will hit this schoolyard over here and this housing complex. And the model tells you you're going to wound or kill 18 civilians. Tells you. I mean, and that's what we bank on. You can say, well, the model's not right in this case. It even goes, what time of day is it? It's daytime, they're all at work. Okay, then you're only going to injure 11. And if it's an industrial complex and it's at 2 in the morning, you're not going to hurt anybody. So this is the extent we go to. So your kinetic commanders not understanding cyber, this is what we've lived with for the last 10 years. And the authority, whether it's morally or correct or incorrect, down to a 3-star commander on the ground, could kill or wound up to 29. 29 non-combatants wounded or killed was the limit. So if you turn the heading this way, the aircraft's coming in, go to a 500-pound bomb, delay the fuse so it goes way in and just bursts and kills everybody in the building. Whatever you could do if it was 29 or below, you could legally, back to the legal part, clear the target. But the moral piece still comes in. Do I want to, does any commander, not me personally, want to wound or kill 29 to take out some guy who was riding in a technical vehicle who parked it under that building? The answer is hell no. Because the 29s, it's up there for big cheese leaders, Osama bin Laden, etc. But I'm just telling you whether I like it or not. I mean, that was it.
Yeah,
go ahead.
Well, that's not exactly how it's done.
Well,
there were pre-planned targets, and there were different levels of approval. It didn't mean that you couldn't attack a target that above whatever number.
It was 29 if you went above, you had to go to SecDef.
And that was just applicable to pre-planned targets. When you had troops in contact, you know, it was troops in contact, and the command commander bought the bomb. So,
I said in direct attack. In a direct attack, a deliberate attack, troops in contact, that went out, then it went to proportionality. You know, proportionality became the factor in.
It's applicable to pre-planned or troops in contact. It's just that the pre-planned targets, you had this other process, but it didn't mean you could not attack a higher level target. And just because it's one individual, depends on who they thought that individual was. If it was a high-value target, 29 people may
I'm not arguing that point, but I'm just saying that the SecDef and the President delegated 29. Above that went to the Secretary of Defense, and they could make that call. But all I'm trying to do is say, we're talking here about riding a worm through somebody else's computer. When you get to I'm not trying to belittle that because this has been fascinating, but the people who have grown up over the last 10 years have this is what they have dealt with, whether troops in contact does change the equation. I got it. If you're under fire, then it comes off the table, but it doesn't mean, you know, you still have to apply the rule of proportionality, etc. But I'm not sure where you were, but I was the J3 at CENTCOM, cleared all the targets for General Abizade, and then I happened to be on the ground. In the 29 rule, clearing a deliberate target, whether you called it pre-planned or the soft guys came in, you were watching through a predator feed that night when you were going to hit. You still did the bug splat, it gave you the collateral damage, and you knew what your authorities, my personal authorities were below General Casey, etc. So
real harm, not Facebook.
But what I'm saying is, you always try to get it to zero. You know, back to the moral piece. But if it didn't, depending on the target, high value, you know, who you were actually taking out, you can see this is not cut and dry. There's a lot of anxiety involved.
Absolutely, and just to clarify one last time, what I'm talking about, what you're describing is all collateral, secondary damage that has been done as a result of passing the doctrine of double effects. So you're talking about we're trying to kill this bad guy and we'll accept this collateral damage. What I was after was, what about intentional direct harm, intentionally targeting civilians in these ways we can with cyber weapons? Is that so? That's another moral distinction.
Okay. Anything else here? Take another couple more minutes if you want.
Or we can buy a drink.
I think we're keeping people
30
from
minutes.
right
The reception starts at 17:30. Yeah, unless you know the bar's open at 17:02.
Break into it, sir.
So if we, I think you can take one or two more questions.
Any other? Okay, down there. No. Yes.
Thanks. Yeah. Seems to me that these questions are old, going back to Independence, France, and Sherman in Georgia,
and the 8th Air Force over Germany in World War II. I mean, at a certain point, a war comes down, or may come down, to dismantling the economic ability of a nation to wage war on a large scale. And that may be more humane in terms of being more efficient and quicker, and it may also be the way you can do it, the way you can hurt the enemy. Northern Virginia is too tough enough to crack on its own, but we can deprive it of its blankets and its ammunition and its spear cannon. I mean, is this part of the equation for cyber warfare, which seems to me to have the potential to do this more efficiently than Henry or Sherman or the 8th Air Force. This is, I mean, but these things all are intertwined, and we know that. So we take that country and we shut it down. Doesn't make anything anymore, doesn't communicate anymore, can't support an army anymore. They're done.
Anyone? No reaction? Okay.
It certainly is one way to win a war. Look, necessity reigns, and if it's necessary, if the only way you can pursue a just cause and defeat an unjust cause is if there's a necessity requirement that's met, then yeah, you can justify a lot of things. But the idea is that, right, we should try to strive for, right, the least damaging, the most discriminate possible ways, and yet still accomplish the mission. And if we can do that by not intentionally targeting non-combatants, right, that would be preferable than shutting down the whole country.
And Sherman also said he would rather burn down a man's barn than a Philistine.
Right, and I would say, Sherman, let's not burn down anything. I don't know if we need to.
Okay, any other questions here that need addressing? Yeah.
I was thinking about your submarine example. And you remember in the early history of submarines, there were actually war crimes charges because they didn't follow the existing rules of the laws of the sea. It was only after it became obvious that you couldn't use the weapon effectively if you complied with the existing law that the law was in fact changed. So I just one thing we maybe want to put on the card, maybe this will be a weapon like that, right? Which is really a game-changing weapon. It was just
that is in fact my point. That maybe submarines are a good analogy, and we don't announce them for obvious military reasons. And maybe cyber has to be treated in the same way. Other thoughts? I'm going to close with one observation here about apropos of the question about speed and speed of operations and so on. It's true that a lot of people say that cyber operations go at the speed of light because you press a button, something happens over there. In practice, they go at the speed of law, right? And whether or not law operates quickly, I'll leave it for you to decide. Okay, thanks.